guys, this is Karalynn Cromeens, and welcome back to the Quit Getting Screwed podcast, where we talk about all the ways not to get screwed in the construction industry. And today we have another one in the series of our nationwide lien rights. We're going to cover New Hampshire today. We have Mr. William Amann. Hello, William. Good morning. How are you?
Hi, good morning.
So before we jump into the specific rules for New Hampshire, tell us a little bit about yourself and how you got into this area of law.
Sure thing. So I practice in Massachusetts and New Hampshire. I've been practicing for a little over 21 years, I guess. I'm primarily a bankruptcy guy. We do consumer bankruptcy. We do a lot of business bankruptcy. How did I get into this? I mean, bankruptcy gets you into a lot of different areas, and a lot of it's real estate related. So, I mean, again, we do commercial litigation. So I don't, you asked how I got into this. I don't know. Being in that area just kind of got us into, and I did some real estate and I've done some work. So if you're doing anything related to real estate and anything with litigation, those two roads intersect, and mechanics liens are an important part of it, whether you're defending or bringing a case.
So let's talk about that real quick for a second, since you're familiar with the bankruptcy side. I've never had anybody. And bankruptcy is federal law, so that's the same across all the states, right?
Yes, with the little asterisk that, yes, bankruptcy law is federal law, and it's how it gets interpreted by different courts and different circuits. So generally, yeah, yes, but sometimes there might be some slight distinctions on how the courts interpret it.
Well, I think this is kind of an important part to bring up, because I think a lot of people don't understand that as a contractor, like say you're a subcontractor and you have a contract with a general contractor, right?
Yeah.
And then you file a lien on the property. How does the general contractor filing bankruptcy in that situation affect your rights?
So there's a number of combinations you can have. For instance, you can have the homeowner filing bankruptcy. We're talking in the consumer setting, I guess, okay, residential. You could have a subcontractor, you could have a general, but usually I think what most people want to know about is what happens if the person that owes money, okay, the consumer or the homeowner files bankruptcy. That's usually because, again, that's what people are going to care about that are contractors or subcontractors, right? Mm-hmm. They've done work. The person that's supposed to pay them goes belly up and files bankruptcy. Is that kind of the question?
Yeah, I think that's like a two-part question, as in that situation and in the situation where the person that hired you filed bankruptcy, but the property owner didn't.
Okay. So scenario one, where you've got, we'll just call them the homeowner or the customer or consumer. You could use a lot of different names. If they file bankruptcy, there's an automatic stay, which goes into effect anytime a bankruptcy case is filed, no matter what chapter it is. Most common chapters are going to be 7, 13, or 11. There's only a couple more, like Chapter 9's for municipalities, and that doesn't come up to it. Chapter 15's international stuff, that doesn't come up. Chapter 12 are farmers, and that can come up. But like, you're usually going to see a 7 or 13, maybe an 11. There's an exception to the automatic stay in bankruptcy.
The stay means you can't take any collection efforts at all.
Correct. You can't take collection efforts. However, there is an exception for perfecting mechanics liens. So that's, let's see, that is 11. Well, this automatic stay is 11 U.S.C. 362 for you bankruptcy dorks like me out there. But you can continue perfecting mechanics lien. It's under 11 U.S.C. 546 B1. So, I mean, the short answer is, if you've already done work and you're the worker, you're the contractor or the subcontractor, and you've got a perfected mechanic lien, and then the homeowner files bankruptcy, the Chapter 7 trustee, or if it's a Chapter 11 trustee or the debtor in possession, they can't avoid a mechanics lien that were perfected prior to the bankruptcy being filed. And if you haven't perfected a mechanics lien yet, but you find out that the homeowner files bankruptcy, you should feel comfortable. Get a lawyer that does bankruptcy would be the best thing to. But you will be able to do that, to perfect a mechanics lien. You might want to, again, there's an exception to the automatic stay. If it were me, and I've had this happen before, I filed because I had enough time under the statute I didn't have to worry about the statute under the mechanics lien running out. I filed an expedited motion for relief, saying, look, here's what's going on. We want to file a mechanics lien, and we have the automatic stay. We don't think it applies, but we just don't want to get sued. And the court basically just issued an order right away that said, it's not, there's, like I knew, but there's an exception to the automatic stay. This is moot. You don't need, go ahead, go sue them in state court for that, just for mechanics lien.
Gotcha. So this automatic stay stops collection efforts. There's an exception to mechanics lien because filing a mechanics lien is a collection effort, but the bankruptcy court says go ahead and move forward with perfecting your lien, which then the key term is makes you a secured creditor,
right?
As opposed to an unsecured creditor in the bankruptcy. And so you can just put it like this: unsecured creditors get screwed, secured creditors don't, which is why you should have a lien.
Yeah, and that's there are situations where a secured creditor, again, this is an overview, can get screwed, so to speak, depending on the value of the collateral. So, for instance, if you're under secured, you're owed $1 million, and the property is worth $250,000, right? So you've got a lot of exposure. You're unsecured as to the amount that's not secured by the property. So I guess you're right. I guess that does fall in line with the unsecured creditors will get screwed. It's important to note, at least, that this is just for mechanics liens, and so this does not apply for regular attachments. I'll talk a little bit about that in a minute, because it's interesting the way New Hampshire does things. When we get to attorney's fees, I'll mention that.
Gotcha. Yeah, because those could probably never be secured.
Right.
So you have that situation where the owner files, and then for our commercial contractors, the general contractor files bankruptcy, but the owner doesn't.
Right.
And so that really doesn't affect their lien rights.
No. Well, at least, again, in New Hampshire, you're going to have, there's two tracks to think about. One is if you have a direct relationship with the homeowner, and the other would be a subcontractor who doesn't have direct contact with the homeowner, but is hired, obviously, by the general contractor. So there's slightly different ways that you perfect a mechanics lien, depending on whether you're for lack of a better word, a general contractor or a sub. So, like a handyman example, there's a lot in New Hampshire. There's a lot of handyman businesses. They are almost always going to be direct contact with the homeowner. So it's pretty simple. The statute's straightforward. But if your handyman hired a plumber or an electrician or something else, and they're doing work, and we'll get to that. That's in the materials I have.
Gotcha.
How to do it. Yeah.
Okay. All right. So the first question is, do you have to be a licensed contractor to work in New Hampshire?
No, I'm always surprised when I come across that. New Hampshire is only a handful of states that don't require it. The state motto for New Hampshire is live free or die, and some things, I think, sometimes they take that seriously. There are some exceptions, though. So at the state level, you do not need to be licensed for construction or renovation projects. But cities and towns, municipalities vary. So you'd want to check your local, whether it's the city, town, or whether it's a website, or it's just calling your, people in most towns in New Hampshire, they're pretty small. You can call your clerk, your city clerk that you'll know, your town collector. But I know mine by first name because I have to register my dogs and my boat, and you get, in a small town, that's what it is. Exactly. So that for state level, no. But electricians do, plumbers do. If you're doing asbestos and lead abatement, they have to get a state license. So the answer generally at state level, no, you don't need a contract. Gotcha. But if you're an electrician or plumber, asbestos, lead abatement, you do need to get state licensure to do that. Gotcha.
Okay, and then who has lien rights in New Hampshire?
So anyone that furnishes labor or material. That's the simple answer. Who would have lien rights?
Is there any remoteness, like limitation, like third or fourth tier? Is that too far?
No, it really is. The statute is RSA 447. There's like 15 or 19 sections. that go into it, but the statute just says that mechanics liens may be filed by any person who, alone or with others, performs labor or furnishes materials worth $15. Again, these statutes were written, a long time ago. $15 or more to any construction project.
Gotcha.
So general contractors would have lien rights, construction managers, design build teams do. I had a case a long time ago that was against an architect on a commercial project. This was before 2012. And so all their costs were soft costs, engineering and stuff like that. At the time in New Hampshire, those were not allowed
Really?
but anyway, as of 2012, the
Now they are.
architects and designers must have a decent lobby. They can now get lien rights.
I don't know how decent it is if it took them till 2012 to do it, and lien rights have been around since the establishment of the country.
Sure, but this guy had, when I started looking at all the expenses, I told him, I said, hey, there's a lot of Southwest airline trips. He was in Philadelphia. I said, a lot of Southwest airline trips and a lot of, Starbucks and a lot of lunches and dinners going back and forth. The project was in Manchester, New Hampshire area. And I told him, I said, you can't charge for your travel and your meals and all that stuff under the mechanics lien statute because, now you arguably could if you're a design professional. But then the statute says it's pretty much what have you incorporated brick and mortar? What have you done? You got to be able to point to the real property and say, yeah, I did this, or that's how it used to be.
Gotcha. Okay, so now everybody's got lien rights who improves the property, including architects, demolition crews, everything.
Right.
Okay, so what are the steps that you have to take in New Hampshire to have a valid lien? Does it vary on if you have a contract directly with the owner? Let's start there.
Sure. Well, first of all, if you've got direct, like I said, there's a distinguish between, I'll call a general contractor and a sub. So a lien's it's automatically created by furnishing labor or materials to real property. Okay. It's now, how do you perfect it? So the party who's seeking payment must also perfect its lien in order to enforce a mechanics lien. And in New Hampshire, you got to file. They use some of the old language here. They'll call it a petition or a writ and a lawsuit. So I think what's important to know is not only are you filing, which I'll talk about in a second, the actual petition for writ for mechanics lien. You're filing a lawsuit too. Really? I don't know about other states if you can just do one without the other, but in New Hampshire, you got to do both. So
you have to do both at the same time.
Yeah, typically. I guess you could file your. I have a case now where they filed, and the guy filed pro se, and then he got a good lawyer that came in and amended his petition. But yeah, it's typically done at the same time. I've never seen it not done at the same time. So for a general contractor who's owed money, they essentially want to know, what do you have to do to do it? You're going to do what I mentioned. You've already got an automatic lien, kind of like an inchoate lien, or a lien that's just by law. You don't have to do anything. So now it's got to be within 120 days of doing the work. So that's key. Well, usually the first thing I'll talk to someone who's owed money, a subcontractor or contractor, is, when did you do the work? And talk to me about the work. There's all kinds of case law on people that they miss the 120-day deadline, so they bring a bulldozer out there and they move boulders and shit around, excuse my French. And then they think, oh, look, see, I'm doing work. It has to be substantial work. It has to be within the scope of the contract. You can't invent new things because you missed the deadline. So it's 120 days. And what do you have to do within the 120 days? You're going to have to file essentially a petition for a mechanics lien and your lawsuit.
Gotcha. So do you file anything in the real property records, or you just file the lawsuit?
You file the lawsuit, and then once, assuming that you can do it ex parte, you don't have to, but a lot of times it's done without giving advance notice to the other side. Nowadays they use a lot of forms and stuff, so you could find a petition for for a mechanics lien online. But the important thing is you don't need to give advance notice to your defendant So no, you don't and can't record anything in the registry of deeds until a court order allows it. Um,
Okay.
I know in some other states you can do that, but I wouldn't record anything at the registry of deeds that could affect someone's title without their consent. So
Gotcha.
what you do, you file your petition for mechanics lien, the lien is granted, and then you record that
Okay.
at the registry of deed.
Gotcha. So
Um,
is there a trial in between that you file? You have to prove the validity of the lien before the court grants it, or is it kind of like a ex parte thing that you can just show that you did work? Or
it's kind of, as long as it has the elements, which I'll touch on a little bit later. You've got to state that it is a mechanics lien. It's very basic, rudimentary stuff. So it's
gotcha.
very procedural. They're going to check. They're going to go down a checklist, and if you've got their allegations, they don't have to test it. There's no trial. There's no hearing or anything. It gets
Gotcha.
granted. Now, after it's granted, the defendant has the right to challenge it, file a motion to dissolve it, or I mean, the one I've got a couple going on now. I don't know if it's going to settle or not, but there eventually will be a trial if it goes that far, because
Gotcha.
I'm representing the homeowners, and we brought counterclaims. It gets involved, but my people are saying we don't owe him anything because he messed up so much stuff, and he's claiming that he's owed $50,000. So there's a big delta between these people. We're trying to figure out what's up. But
Yeah.
for a general, they file a petition for the mechanics lien attachment. They file their underlying lawsuit. For a subcontractor, it's a slightly different notice and accounting procedure. Subs have to provide the property owner with a written notice of their intent to claim a mechanics lien. Okay.
Mm-hmm.
And it can be what I tell my construction clients is you should put that intent to lien in your contract. And it's just got to be, you want to be business friendly, but if you put it within your contract right up front, then you won't have to do it. You've already done it.
So as a subcontractor, the contract with the GC is enough, or do they have to send it to the owner too?
No, it's got to be, if you're a subcontractor, you got to give that to the homeowner. If you're going to do work at someone's house, you would have to give that. Now, you can, if you haven't done that, which a lot of companies haven't, because if they're a sub, they're like, well, we don't have any contact with the homeowner, and we don't really feel like getting hired as a subcontractor, and then sending, hi, Mr. and Mrs. Homeowner, here's my notice of intent to lien if I don't get paid. They usually don't do it. So
what's the time frame? How long do they have to do that once they start working?
they can do it. They can give the notice of intent to lien. If they don't do it before they start doing work, they can do it after they did work. They can do it really at any time. I'm just saying, as a practice, if you could put it in a contract, and have this, and you've got any contact with the homeowner, it's there. You got it covered. But I tell you what, it comes up most of the time. Subcontractor gets hired by a GC. They don't have any contact with the homeowner other than maybe they see them in the house or something if they're there. They do their work as a subcontractor, and then they're not getting paid. So, and they want to lien the property. So if they do that, then their notice is, they do essentially a statement of account, they call it, SOA, or statement of account. And if they do that, then the subcontractor's lien's limited to what amounts were due after the notice is given. So that's why I tell people to put it in up front. So
you're the state, like anybody under the sub is going to be limited to the amount that's owed to the general.
Yeah, I think that's a way of putting it. But I think the important part is it's simple if you're general. We'll just leave that alone. General, you don't have to give this notice or a break statement of account or any of that stuff. You've got direct contact. If you don't get paid within 120 days of doing substantial work, you can bring a lawsuit and petition for a mechanics lien attachment. That's general.
Gotcha.
Subs, again, you got to give notice to the
suppliers.
homeowner of your intent to a mechanics lien, and you should do that as soon as possible. Because if you can do it at any time, but if you wait, like I said, it's RSA is the law is 447 section 6. It's limited to the amounts that are due to the general contractor or that may become due after the notice is given. So
if everything was paid by the time you give your notice, you're screwed.
Yeah.
Gotcha.
Yeah. And again, a defense from a homeowner standpoint could be what I just call simply the payment defense. So if the homeowner said, wait a minute, I paid the general everything, then you're not going to get a lien on the home, and nor should you. You know, the homeowner, they paid. That's a payment defense. Then your recourse as a subcontractor is against your general, which is, hey, the homeowner says that they paid you everything, but where am I?
Yeah.
Um,
And it's kind of weird because there's only a few states that are like that. North Carolina that way. Now New Hampshire's that way. That I found that most states either have, like Texas has a retainage requirement that the owner withhold 10%. So it's so wild to me that all 50 states have 50 different ways of doing things.
Yeah, it really is. Another way to kind of deal with this is, even if you don't have a bank, so a lot of people have banks involved, and that's fine. But even if you don't, I tell homeowners or even subs, try and set up stages or phases and get lien waivers, because that's just a good gut check on everyone. So you might say, if you're a homeowner, look, here's phase one, a completion of the floor and the living room and whatever's in that project. And before anyone's going to get paid, it's got to be a sign off. So banks will typically require that, because they're not going to just write checks when they don't know if stuff's done. Although I had a case where a guy, and I think this happens frequently, was either forging lien waivers or was telling the bank, yeah, it's done, when it wasn't. But it's a different story. But yeah, that's a good practice, I think, is to try and have lien waivers along the way, milestones.
I agree. Is there any difference in what you have to do to perfect a lien for a commercial project or a residential project?
No, the law doesn't. No, there's no difference at all, believe it or not.
And then, so it sounds like you're already in a lawsuit, but how long are liens good for? Like, say you filed the petition, you get the court to sign off on it. How long are they good for?
I came across something that said they don't last forever, but then I couldn't really find a source for that. My understanding in practicing is that they stay on the property for as long,
Gotcha.
They just stay there till they're discharged. I don't know, like an attachment not under the mechanics lien statute. A lot of times they'll be good for 10 years, and then you got to renew them. I think mechanics liens are good until they're paid off. They're going to stay on. The attachment will stay at the registry of deeds, again, assuming it was approved by the court.
Gotcha.
Until something happens with that property. Someone dies, someone refinances, someone sells. So it's pretty powerful to get that lien.
That is. And can you get your attorney's fees back if you have to hire an attorney to file this? Because it doesn't sound like it's something you can do on your own really well.
Doing this on your own is a bad idea, just like me doing my own plumbing or electrical wiring is a bad idea. Could I read books and watch YouTube videos? And it's not rocket science, but it's very technical. There's steps that if you miss any along the way, if the court doesn't kick it out, if there's someone on the other side who knows what they're doing, it will just give them a defense. And since you've got this strict 120-day deadline, if you do it and you F it up, you don't get a do-over if you're up against 120 days. You know what I'm saying? If you brought something incorrectly on day 115 and it takes you more than 5 days to figure out that you did it wrong, you're now beyond statute. So you won't get a mechanics lien. You could still get a real estate attachment, what I call just a garden variety real estate attachment, but it doesn't have the priority of a mechanics lien. To answer your question about attorney's fees, again, this sucks in New Hampshire. No, you don't get attorney's fees as part of mechanics liens under the statute.
Really?
So I did a double take on that. Again, it's weird because under the normal attachment law, which is RSA 511, you can add for it does authorize, in fact, the language out of RSA 511A4. It allows attachments, quote, to the extent reasonably necessary to secure any judgment or decree which the plaintiff is likely to obtain. So that includes allowable interest and costs. So that's an ordinary attachment, but the mechanics lien doesn't have that. So I don't know.
But the
I don't
mechanics
know.
lien also gets priority because
Yeah.
it's for the improvement. So
Right.
attorney's fees aren't for the improvement. Most states don't allow you to include it in your lien, but you could recover it. And then some states are only if, like, you had it for a breach of contract, you could have it in a regular attachment, sounds like, but not on the mechanics lien.
Yeah, what I thought of, I might do a mechanics lien, and then I would also separately seek an attachment just for attorney's fees, if your contract has a provision for attorney's fees. So I think that would be the standard. So you definitely, whatever contract you have, whether you're a sub or a general, you should have a provision in there that the attorney's fees, reasonable attorney's fees, will be awarded or recoverable under the contract. If you have that, and let's say you file a mechanics lien for labor and material for $20,000, and then you think, well, geez, this thing's going to go to trial potentially. I've spent $5,000 on mechanics. I don't see why you couldn't file them separately, and do that.
Yeah,
and if the dollar amount's high enough, that might be the way to go about it. I have a case now where it's a mechanics lien. I'm defending the homeowners, and the other side is telling me, oh, we're going to get attorney's fees because you guys are acting in bad faith, and I get that, but it's not going to be under the mechanic lien statute that he would get that. Yeah, I mean, he's reaching. I know the guy. He's reaching. Good lawyer, but he's reaching because, just as an aside, in the state of New Hampshire, probably like other states, there's 3 ways you're going to get attorney's fees. One is by agreement. So like a mortgage or a contract that specifically says that, you're going to have to, the losing party is going to have to pay the other side's reasonable attorney's fees and costs. The other would be, so if it's not by agreement or consent, then it would be by statute. Is there a law that allows for treble damages, or some statute, like a lot of federal cases might have that? If there's no specific law that gives you attorney's fees and costs, then the third, and this is where this guy's going with this case, is the so-called bad faith litigation exception. Pretty high standard.
Yeah.
In New Hampshire, the case is Harkeen v. Adams. It's still good law. It's old law, but still good law. And you're going to have to show, you're going to have to show more than just a dispute. Parties dispute things all the time. That's why we have jobs. It's got to rise to the level of what they call it is that you're denying another party a well-defined right. And I won't go into the Harkeen Adams case, but there's 3 ways you get legal fees, and that's across the board. And mechanics liens, again, they're not part of the statute.
They don't have a statute for it. Yeah. Okay, so what about material suppliers? Would they have to take the same steps as a subcontractor?
Yeah, they would. They would. And essentially, it really comes down to whether it's a simple statute, whether they're a material supplier or equipment. So a company that would
rent equipment,
would be lease out a bulldozer or whatever, compressor or whatever. If it's used to better the property, better real estate, then they would have the ability to lien, but they would have to go through subcontract. They'd have to go. They would treat themselves as a subcontractor.
Gotcha.
So they'd have to give a notice.
And they'd have to send the notice to the owner. Hopefully, the sooner the better, so there would still be funds there.
Yeah, right. They'd have to send a notice of intent to lien, and the sooner the better. They can do it after, but it's better to do it sooner, just to cover yourself.
Gotcha. All right, so tell me about public works projects, because just generally in all 50 states, you cannot file a lien on property owned by the government, whether that's the federal government or the state government. So what do bond claims look like in New Hampshire?
So that's right. That's true in New Hampshire. It's just funny how that works, how government's really good about making sure that you can't get mechanics liens against the state property. So let's see. Construction on any state, county, city, or town-owned property. The they can't attach under the mechanics lien. That's RSA 447, Section 12. They do attach, however, to any money due from the state or other governmental subdivision to the liening contractor. That's
Gotcha.
RSA. That's a fancy way of saying a bond. So public works have to be bonded. It's RSA 447, Section 15. Public entities have to obtain bonds on any project that's over $25,000, equal to, or it says at least 100% of the contract price. So I've got some case sites, but I'll leave that off for now because it's so old. It's a 1964 case. But yeah, look at if you're looking at a bond project, you want to know about it. Obviously, you want to be familiar with RSA 447 Section 16, stuff that does get covered. A statutory payment bond does provide security. Again, this is all in the statute 447:16. All labor performed or furnished by the contractors and subcontractors, all equipment hired, trucks, all material used, fuels, lubricants, power, tools, hardware, supplies, and labor and parts furnished for the repair of equipment used in carrying out the contract. That's just all statutory.
Gotcha. And then when would they have to send notices, and who do they have to send notices to?
Yep. So the state has an interest in reasonably ensuring that subcontractor suppliers are not deterred from bidding working on public projects. So the bond requirement protects material supplier to subcontractor general. You're looking for what for the notice?
Yeah. Who's got to send it? Yeah, who's got it? Like a sub and material supplier is going to have to send notice to somebody.
Yep. Let's see. I'm looking through my notes here. General counsel. How do you get confidence? So you pretty much give notice. First of all, start with the Secretary of State's office if you're looking to find out. A lot of stuff that bonds are going to be done through the Secretary of State's office. And so know that. Let's see. I'm going to my notes on. I notice everybody, but that's easy way to do it.
I agree.
You know what I mean? That so. Oh yeah. Okay. So supplier or subcontractor, they don't have to give an advance notice of its intent to claim the benefits of a bond before filing what they call a statement of claim, and that's filed again with the state, with the Secretary of State's office. Okay. So there's a provision that you have 1 year to file a petition in Superior Court, in which the contract was principally performed to enforce the claim.
The statement.
So essentially the process is you file a claim with the state, bonding company, and then you've got a year to move on it. That's the general, and that again, this is all statutory. It's kind of laid out.
And hopefully you would get paid without having to file a lawsuit, but you never know.
Yeah, right. Hopefully you can file your claim and get that resolved. And a lot of them are resolved that way. But you should mark a year. If you get to that point where you filed your claim against the bond and there hasn't been much activity, you definitely want to make sure that you've marked it for a year.
Yeah.
Don't wait until the last minute, but you got to bring suit in Superior Court within a year.
Good deal. All right. So is there anything I missed that's important to liens in New Hampshire that we didn't talk
about? Let's see. No, I think we've covered most. You mentioned before, doing this on your own, not a good idea. So if your audience here, I'm not sure who will get this, but if you're a small operator, it's you, maybe you have a couple guys or women or whatever that work for you, and you're worried about the cost of doing this, the legal costs and the fees and stuff. I don't blame you, but I can tell you that it's not super expensive to put together this stuff, putting together a lawsuit, and it's worth, in my opinion, and I'm not saying this just to promote lawyers, it's worth getting done right. And I'm a litigator too, so it's it's kind of hard to be objective about this. So I guess that there's timelines and there's things that qualify. So I guess if we were saying what would I tell you? What things we haven't covered? It's simple. Know your role. It's either one or two. Either going to be general, meaning direct contact with the homeowner, or if it's a construction of a commercial, the owner of the property. I'd be careful about that because I've seen commercial deals where you think you know who the owner of the property is, but in a commercial setting, they're dealing with different companies or managing companies, and you come to find out, well, hey, the people you've been dealing with, they don't own the property at all. They're in Houston, and they're just a property manager. You got to know who owns the property that you're going to do work on. That's important. So that's what I would say.
No, absolutely. And it'd be coming from number one, knowing that you have lien rights, that there's much more than a breach of contract. You have a secured
Right.
interest in the property that you improved, and knowing how
Right.
to protect those rights because you work hard, you improve the property, you deserve to get paid. I think
Right.
it's hugely important when I'm collecting a database of all the 50 different ways to do it. It's just in one place.
Yeah.
And if you need a construction lawyer in your state, I have them all on the podcast too. So
Right.
speaking of that, where can people find information about you and your firm?
So I know I have a form to fill out, which I'll do in a minute, which has all that information. But my name is William Amann. It's Amann, and the name of my firm is Amann Burnett. We are in Manchester, New Hampshire, and we're also in North Andover, Massachusetts. It's about 15 miles north of Boston, I guess. I don't know if you want the email address or the website, but I think
we'll put it in the show notes too, but that way.
Yeah. So I'll fill out that form again. But our website is simple. It's www.amberlaw.com, and it's AMBURLAW.com. It's just kind of an amalgamation of my last name and Burnett's last name. So amberlaw.com. But you could go there and you'll know how to find us.
Perfect. Awesome. Well, thank you so much for being on the show and letting us know all the thing about New Hampshire liens. I really appreciate it.